This podcast is brought to you by the IIEA, sharing ideas, shaping policy.
Morning, everybody, and thank you all very much for your attendance in such numbers on such a nice summer's day. My name is Alex White, Director General here at the Institute of International and European Affairs. And we are more than delighted to be joined this morning by Minister Jim O'Callaghan, Minister for Justice, Home Affairs and Migration, who will address, I suppose one could say, the contested nature of human rights in the area of justice, home affairs and migration, and the whole question of the inevitable, unavoidable necessity to balance interests that comes along with that whole imperative. So the Minister is going to speak to us for maybe about 20 minutes, perhaps a little more, and then we'll have an opportunity for an interaction, discussion, questions, and so on. The usual drill applies. If you have a question, you just simply have to put up your hand and we'll get you if we can. If you're watching us online, welcome to you also. And there's the Q&A function there that you're well familiar with at this stage. If you have a question, as we always say, if you're watching online, you can put it in at any stage. You don't have to wait until the Minister has finished speaking. So once again, I do want to extend a warm welcome to everybody who's joined us this morning. I see quite a number of our loyal members of the Institute here, and indeed many more, members of the media, at least one former Minister for Justice, Nora Owen, our valued IIEA member, Secretary General, Department of Justice, and a number of others, see former Garda Commissioner O'Sullivan here as well. So I'll stop because the trouble is I can't see everybody, so I might leave somebody out. Members of the Diplomatic Corps also very, very, very welcome. Jim O'Callaghan is, as I said, Minister for Justice, Home Affairs and Migration. He was elected to Dáil Éireann for the constituency of Dublin Bay South in the general elections of 2016, 2020 and 2024. Previously, he'd been a member of Dublin City Council. He has served as a member and chairman of the Oireachtas Committee on Justice and was also a member of the Oireachtas Finance and Education Committees. He's been a Fianna Fáil spokesperson on justice since 2016. He's a law graduate, UCD, LLM graduate also, and M.Phil in Criminology from the University of Cambridge. He holds the BL degree from King's Inns and has been Senior Counsel since 2008. I've known Jim for many years. I'll say no more than that, other than the decision of the Taoiseach, Micheál Martin, to appoint him as Minister for Justice was one of the wisest decisions the Taoiseach ever made. Jim O'Callaghan.
Thank you very much, Alex. Ladies and gentlemen, you're all very welcome here this morning, and I want to thank Alex and the IIEA for inviting me to speak to you this morning. I also want to just acknowledge the presence here of former predecessor in my office, Nora Owen. It's very good to see Nora here this morning. I suppose since I've become Minister for Justice, one of the most frequent questions I'm asked is people saying, "Oh, what's it like to be Minister for Justice?" And I suppose the answer I give is that it is a very intellectually stimulating job, and it is a consequential job. And so one of the things that has surprised me about it is that as a politician and as a minister, you're actually able to do what you want to do, which I always assumed that if you become a minister that the civil service would say to you, that's a very challenging idea, Minister, a very brave decision, but you wouldn't actually get to what you want to do. But I just want to acknowledge the fact that since I've been Minister, the civil service and the Department of Justice have been extremely helpful in terms of trying to ensure that, you know, I, on behalf of the government, can achieve the objectives and political agenda set out in the programme for government. And I just want to acknowledge the presence here of Una McPhillips, Secretary General of the Department, as well. I commend her, because it's something that you mightn't be aware of, is the really high quality of the staff within the Department of Justice, and it's something I'm extremely impressed by. I suppose many of the important decisions I have to make require me to take into account and balance competing rights. And I was just thinking about it in terms of preparing for this speech, like even the two pieces of legislation that I'm dealing with at present, which are going through the houses of the Oireachtas, the Defamation Amendment Bill and the Terrorist Offences Bill. Both of them require me to balance, in respect to defamation, competing rights. The right to freedom of expression, similarly the right to one's good name. And I suppose when it comes to the Terrorist Offences Bill, there's a requirement for me to take into account the right to protect the public, people's right to be safe and bodily integrity, but also at the same time to ensure that that legislation doesn't unnecessarily impinge upon, I suppose, privacy or freedom of expression. But unfortunately, I think in the world, it's not just in Ireland at present, campaigning and commentary on any issue now is really presented in a very partisan manner. And when you're getting submissions on a particular issue, whether it's being, for example, the defamation bill, you generally hear submissions which are made purely taking into account one of the constitutional rights that has to be vindicated. Predominantly, just using defamation as an example, the right to freedom of expression. But also, I think we need to take into account the other competing rights, as those rights are significantly important. And I suppose the right to one's good name is something that isn't given sufficient attention when it comes to assessing those competing obligations. If you look at it, I suppose it's not just within the Department of Justice that balancing act arises. It arises throughout government. And I suppose if you think of the issues in terms of climate action, decisions are being made by government and by individual ministers which seek to ensure that we respond appropriately to the challenge of the climate crisis, whilst at the same time taking into account the future, for instance, of farm families and persons who may be affected by decisions made in respect of the climate crisis. And obviously also in terms of the budgetary matters. Like, budgetary matters have to take into account that if you're spending money on one area, that necessarily you may not be able to spend it on the other. And I suppose what I would say in terms of balancing competing rights and even balancing competing political judgments is that you have to, you can't really just opt for one over the other. And sometimes the way it is presented is that you should really just opt for one over the other. And I think part of the reason for that is that commentary and I suppose advocacy groups, they get more attention in the media by ensuring that they just concentrate solely on their focused objective, which may relate to one competing right. And that may get more media attention, but certainly from my own point of view as minister, I must say I find it more effective and I listen more carefully to a submission that takes into account that there are these competing rights. Listen, Ireland, of course, is required to vindicate the rights of our people, not just under Bunreacht na hÉireann, but obviously also under the European Convention. And we're well aware, I suppose, of the standard rights that are set out within both of those important documents. But I suppose there are other areas in my function within the Department of Justice where I have to look at one particular right and how it's impinging on others. And I suppose one of them is in respect of the right to privacy. And the right to privacy, I suppose, is a right that we all recognise and understand. And I suppose when you look at it traditionally, we always viewed the right to privacy in terms of the rights that were, I'm thinking of North Great George Street here, the rights that David Norris sought to vindicate and partially did vindicate in terms of the cases he talked about the right to privacy in terms of one's sexuality, and also the individual rights to privacy. But of course, there's other aspects of rights to privacy now which are used in the context of justice. And one of them, I suppose, one of the key areas where the right to privacy, I think, cannot be permitted to become sacrosanct is in the question of in what circumstances law enforcement and security services should be able to access data. And I suppose none of us want a situation where the state has an opportunity to see all our data, to see all our text messages or all our messages. That's something we certainly don't want. But at the same time, I think there would be deep concern if it was the case that the public were aware or believed that An Garda Síochána weren't actively pursuing people who were involved in communications for the purpose of trying to inflict harm on others. I think people would regard it as a sort of an obscene violation of people's right to their bodily integrity and their right to life if not sufficient efforts were being taken by An Garda Síochána to ensure that we could access information which at one level is private but which is being used for the purpose of trying to engage in criminal activity. I suppose one of the areas where that happens is in respect of the legislation that exists in respect of the power that the Gardaí have to intercept phone calls and parcel messages. And the legislation that's still operating in respect of that is legislation that was there when Nora Owen was in the Department of Justice, since it dates back to 1993, the Interception of Postal Packets and Telecommunications Messages Act 1993. So it's now over 30 years old. And I suppose if you go back to 1993 and you look at the methods of communication that existed then, it's a completely different world to what it is now. We'd no text messages, we'd no social media, we'd no sort of encryption of messages. So it has always been recognised under that 1993 Act that there's a legitimate basis upon which the state can seek to gain access to information which is being used for the purpose of criminal activity. And that still exists, and it's something I think that's recognised, that not just in Ireland, but it's also recognised on a European-wide level as well. And recently we've sort of updated the control mechanisms in respect of that interception, because under the 2024 Policing, Security and Community Safety Act, we've now put in place an independent examiner of security legislation, former President of the Court of Appeal, Mr. Justice George Birmingham. So he will assess the interceptions that are ongoing at present. However, I think if you were looking at that legislation and you'd say, where is the real deficiency in it? You'd say that the effectiveness of the 1993 Act has been impacted by developments in technology and debates on the appropriate balance of individual privacy rights. And I think this is an area which we really need to look at and to ensure that we permit interception in respect of modern data and modern forms of communication. I suppose it's worth noting that the EU in June of this year the Commission published a policy roadmap in this area, which noted that terrorism, organised crime, online fraud, drug trafficking, child sexual abuse, online sexual extortion, and many other crimes all leave digital traces. And almost about 85% of criminal investigations now rely on such electronic evidence for the purpose of ensuring that people can be brought to trial. So a lot of the argument at present, particularly from the service providers, is that the right to privacy outweighs all other policy and legal considerations. And I think the EU Commission's proposals in this regard are seeking to engage with these complexities. And I suppose these include creating a level playing field for all communication providers in the enforcement of lawful interception, and critically delivering technology solutions to enable encrypted data to be accessed in a lawful manner while safeguarding cybersecurity and continuing to ensure that privacy rights are protected as well. You'll also be aware that in the programme for government adopted earlier this year, there's a commitment in it to enact new interception laws and include provision for over-the-top and encrypted services to be included. And there will be extensive public consultation in respect to that. I think it's important that when we are considering a replacement of the 1993 legislation, that we do have widespread consultation in respect of it. One thing I also want to ensure is that any legislation that is introduced will contain with it recognition that there are occasions when the privileges that attach, whether it's legal professional privilege or journalistic privilege, that they are recognised in our legislation as well. So listen, as I said to you, when I'm developing this new legislation, I intend to consult widely and will be emphasising that I believe effective law interception powers can be accompanied by robust privacy, encryption and digital security safeguards. And I think it's a complex issue, but it is an area where we really do need to advance and an area which we need to develop in terms of communications, whether it's by WhatsApp or Snapchat. All of them need to be accessed and available for access for the purpose of trying to protect people in advance of criminal activity taking place, as opposed to just retrospectively seeking to look at them after the offence has taken place. I suppose one of the worst examples of where sometimes people overemphasise privacy rights at the expense of other rights has been around the negotiations at EU level around a proposed child sexual abuse regulation. This regulation was proposed, first of all, back in May 2022, but regrettably it remains stuck within agreement from some EU members, which is not forthcoming. The regulation is designed to replace a voluntary system, which allows email and communication companies to search online for such material. And as you'd expect, where you have a voluntary system, it is not effective at all. And you would have thought that companies would be able to identify this type of material, particularly since they're so good at identifying other types of material which are online. So listen, we cannot allow, I suppose, what actually is forms the basis of child sexual abuse material, which is the actual sexual abuse and the actual rape of children. We cannot allow that type of material to be put online without serious regulation being put in place to ensure that we seek to combat it and to resist it. And as I say, the new regulation will only be effective if it sets out an enforceable requirement for all relevant companies to detect and remove child sexual abuse material. And that is a regulation that I will be raising with colleagues. I know the Danish presidency have just taken over. I'm in Copenhagen next Monday, and I know this is an issue that the Danes during their presidency want to see advanced, and it has taken too long really for conclusion and for finality to be brought to this. I suppose another area of technology which I will be introducing legislation on concerns facial recognition technology. And again, sometimes the presentation of this is presented in a very binary way, that, you know, this is a draconian measure that if it's introduced will be an Orwellian type of surveillance of citizens and people living in Ireland. It's not going to be that. And like, again, this is where you need to balance competing rights. Obviously, we need to ensure that as serious criminals and people who want to harm members of the public, as they become more advanced and sophisticated in their use of technology, similarly, on Garda Síochána, need to be given greater technology to ensure that they can combat them. At present, I'm working on a piece of legislation that will amend the Recording Devices Act 2023. This will only allow Gardaí to process retrospectively biometric data with significant safeguards in place. And I don't wish to get too technically involved in the detail here, but it will allow for what's referred to as retrospective biometric analysis. Now, you may ask, what does that mean? In practical terms, it would allow Gardaí, if they had an image of a suspect, to use technology to search for that person in CCTV footage they have seized as part of an investigation, or would allow them to identify child sexual abuse material on a device they have seized. So these powers, they'll only be permitted for investigations into serious offences, to help locate missing people, or for matters relating to national security. And I intend to publish this piece of legislation early in the autumn. In my view, it is a limited and proportionate piece of legislation. It's not a draconian measure. It will allow the Gardaí to get a modern digital evidence management system in place quickly. And I think once that piece of legislation is in place, we need to recognise that the technology that's available keeps advancing all the time. And I will subsequently then be looking at providing for retrospective and potentially live biometric identification and analysis beyond what is contained in the bill I'm bringing in the autumn. And those who follow closely European regulations will note that the updated Prüm 2 regulation will require Ireland to establish a database of facial images to contribute to greater cross-border police cooperation. So there's a lot going on at EU level. A lot of this can at face value be presented as an interference in the privacy of an individual. Nonetheless, you have to weigh up what's the competing balancing right. And the competing balancing right is the collective right of the public and individuals in Ireland to be protected from serious criminal offences, including child sexual abuse and indeed terrorist offences, which of course undermine completely the fundamental right to life that people have. I'm conscious as well, people may say, well, okay, that's all very good in terms of advancing investigative powers for Garda Síochána, but what are you doing to counterbalance the right of privacy? And I think it's important to note that the Data Protection Commission that we have in Ireland is very effective in seeking to ensure that the right to privacy of individuals online, in terms of not just online, but generally, that right to privacy is vindicated. They've vindicated the rights of many data subjects, and I know that they've done so with considerable success. To date, the fines imposed by the Data Protection Commissioner amount to around 4.5 billion euro. I know these fines always get the headlines, but just as importantly, they've directed many organisations, including public bodies, to change how they work to further vindicate the privacy rights of our people. So we have a very strong and effective and collaborative Data Protection Commission, and it recognises its role in terms of protecting privacy. I suppose another area where we have competing rights is in the whole area of migration and asylum. And I suppose the right to claim asylum, as we all know, is well understood in international law. It dates back to the Geneva Convention in 1951. That right, as we know, has become throughout Europe more politically contested of late. But in my view, and the view of the Irish government, it is a right that should be protected. However, we need to recognise and not confuse the right to asylum with the right to apply for asylum with the right to asylum. If you have been persecuted, Ireland is here for you. We will process your application quickly, and we will give you every help that we can to integrate you into our society. If you're not in fear of persecution or you haven't been persecuted, but if you want a better life, that's a legitimate aspiration. But you can't use the asylum laws for that purpose. The asylum laws are there to protect individuals who are persecuted, and the work visa laws are there to enable people to come here if they want to come here for the purpose of work. So I think what we need to do as well, and I've directed this in the department where I'm working closely with my Minister of State, Colin Brophy, we really need to have a more planned migration strategy generally in Ireland. We're all aware of the needs of having people in Ireland from other countries, just for the purpose even of keeping our economy going. But I think to date, our migration policy has probably developed in a haphazard manner. It's sort of developed organically. I think we should be trying to set out a strategy as to how we wish or we intend our migration policy to develop in years to come. And obviously, this strategy will seek to balance our country's need for an immigration system that is both fair and firm, one that attracts people with the skills we need, as well as protecting those at risk of persecution, and also one that ensures that our rules are fully enforced and that those with no right to be here and who have not been granted asylum are returned. I suppose one area where the discussion here that Alex asked me to talk about is competing rights. And I suppose one area where we may see a conflict of rights, or more accurately, I suppose, a contentious hierarchy of rights, derives from a recent opinion of the Advocate General of the CJEU in respect of the rights that asylum seekers have to accommodation, and whether a failure to provide accommodation will always give rise to Frankovich damages claim. We know that under the Reception Directive, each member state is obliged to provide shelter and accommodation to persons seeking international protection. Last year in Ireland, regrettably, we were unable to do that because of the very significant numbers of asylum applicants who came here. At one stage last year, there was approximately 3,400 male applicants who had not been offered accommodation. Fortunately, that number is now reduced to 1,400 this year. But what is worth noting is that on the 10th of April this year, in proceedings brought by two asylum applicants, international protection applicants, against Ireland, the Advocate General gave an opinion that Ireland, as an EU member state, cannot avoid responsibility for providing adequate reception conditions, even in cases where there's a large influx of people seeking international protection, as was the case last year. And in that case, the government had argued that the breaches were due to exceptional circumstances, which amounted to force majeure under EU law. But interestingly, the Advocate General ruled that under the directive, a member state could not avoid a claim for damages because of a defence of force majeure. So I suppose we just need to think out the consequences of that opinion, if that opinion, as is likely, is translated into the judgment of the CJEU. It'll mean that people in Ireland who are entitled to be on social housing lists or homeless lists and who have not been provided with accommodation will be in a situation where they cannot receive damages for the state's failure to provide accommodation, whilst applicants for asylum will immediately on arrival in Ireland be able to claim and receive damages from the state if it cannot provide them with accommodation. And I think that's going to be, if it is a judgment that comes from the CJU, it'll be a very consequential decision that will be difficult to explain, not just to citizens in Ireland, but to citizens of all member states. And I suppose I would just close this area in terms of migration by stating we should try to ensure that in trying to vindicate certain rights, we do not marginalise or demote other equally legitimate rights. I suppose the theme I would like to emphasise today is that when it comes to competing rights, you have to try to balance them. And as Alex will know from being a former minister, that is the function of a government, it's the function of a minister. And it is a difficult task, particularly when complex issues are presented in a very binary, black and white and simple way. So listen, as I said at the outset, complex public policy questions require us to balance these rights. I hope these comments have given you a sense of how I'm working to balance those rights in my own jurisdiction within the Department of Justice. I also want to say, as I've said before, and I think every politician should say this, like, I don't have a monopoly on wisdom, as I'm sure everyone here fully is aware. The government isn't always right. It is really important that when it comes to competing constitutional rights and seeking to balance them, that government and ministers listen to the, I suppose, the interventions, the submissions of others to take on board what unquestionably will be good advice in many instances. Balancing anything is difficult. Balancing competing rights when there are so much at stake is particularly difficult. But I think the emphasis upon individual rights sometimes has to give way to the collective rights of a community and to the public to ensure that they feel a sense of safety, particularly in the area of justice. So Alex, I don't know if I've gone on over 20 minutes or not, but that's the contribution I wish to make. And thanks very much for inviting me.
This podcast is brought to you by the IIEA, sharing ideas, shaping policy.